When would an employment lawyer tell you to accept less than your common law entitlements? These would be usually one of three situations. The first one, unusually, there will be an enforceable employment contract restricting your entitlements. The reason I say this is unusual is the vast majority of contracts we review will not be enforceable. We're usually able to get around these and to secure your maximum common law entitlements rather than your minimum ESA. The second situation would be if you have a job lined up that is readily or quickly available to you, or if you have a reason to believe that you'd be very quick to reemploy, it can make sense to accept what would otherwise be a poor offer given mitigation. We'll discuss mitigation in another case and explain why it would limit your entitlements. The third and final situation will be if your anticipated increase would be too small to justify the fight. So if your common law entitlement was 2 months and the company is offering you 7 weeks of pay, just under, it may not make sense for you to go ahead and fight. Usually you'll want to use a lawyer to have them review your case and fight for an increase where it makes sense. But sometimes it makes sense to avoid the costs involved and deal with the company yourself. Again, it's always advisable to use legal guidance, whether it's a paralegal or a lawyer, to make sure you know that you're not walking away from much greater entitlements. But these are the three scenarios where we will recommend that people not spend money, time, or resources on lawyers or paralegals and consider accepting what would otherwise be a very poor offer.